Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law office of Rajiv S. Khanna, PC. Today is October 17th, 2019, and this is our bi-weekly community conference call, which we do every other Thursday at 12:30 p.m. Eastern Standard Time. To participate in the call, you can log into just call in to 202-800-8395, 202-800-8394. Sorry, correction, 8394, not 95. Okay, I'm going to begin as usual, first of all, with our frequently asked questions. The first one is from Ashika. This is about filing a 485 through a new employer if the priority date that was obtained through a prior employer's green card filing becomes current. So, first of all, remember, in order for you to file 485, your I-140 through the new employer should already be approved, or it can be filed concurrently. So at least the perm should be approved. In order for you to file a 485, in this situation, your current employer should have reached at least perm approval stage. Only then you can file a 485. You cannot file a 485 if the old employer's date becomes current, but the new employer has not yet filed a green card or not yet have received a perm approval at least. Because if the perm approval is received, then I-140 and 485 can be concurrently filed. But the new employer has to have at least the perm approved. Okay. If you have any follow-up questions on this, press *5. Any follow-up question on this issue, press *5. Okay, let's go on to the next frequently asked question. This is about compelling circumstances EAD. So if you go to my blog on immigration.com, I have written an article as well as there is a schematic map about what a compelling circumstances EAD is. So in situations where I-140 is approved and your priority date is not yet current, something happens in your life that you cannot hold an H-1B job, you might be able to qualify for compelling circumstances EAD. When you are on a compelling circumstances EAD, you are no longer on a visa status. You are considered to be in authorized period of stay, which means if you want to later on convert back to H-1B, for example, you will have to step outside USA to get a visa stamping. That is the only downside of a compelling circumstances EAD. We have done a bunch of these, all of them based upon medical grounds. One of them was rather unique in which it wasn't the medical ground of the individual, but the medical ground of a member of their family. So because of the uncertain availability for a job, they had to have flexible time, and that could only be done through a compelling circumstances EAD. But there are several other circumstances in which compelling circumstances EAD is possible. I had another case, and I don't remember if we proceeded forward with it or not, but I did a consultation on that, where somebody was doing, I think it was manufacturing resource planning, MRP, and the operation shut down, but they couldn't move out of that city for several reasons, including the fact that they were not able to sell their house. So I believe that I thought that an EAD was possible, and I think we proceeded to complete it and get it for them. But there are various possibilities. In Kiran's case, he's been diagnosed or she's been diagnosed with thoracic aortic aneurysm which requires open chest surgery. It could take 2 to 3 months to recover. Can I get a compelling circumstance? Their I-140 is approved. And the answer is theoretically at least yes. Can you be without payroll during this period? Yes. But you can be without payroll even on an H-1B in these circumstances. The longest I've had somebody be on medical leave was, I think, close to 2 years. And that was very well justified. So when you have a medical justification, you can take an extended unpaid leave of absence and still maintain an H-1B status. On EAD, definitely, you can be on unpaid status. You can go back on H-1B after 1 year, as long as you are okay stepping outside and getting a visa stamping. You do not, the following question is already answered. Can I change employer while on EAD? Yes, this EAD allows you to work for anyone or multiple employers. What is my status if I have to travel to India? I don't think you can return to, I haven't looked into this. You might be able to get an advance parole, but EAD does not give you a status to come back into USA. I'll be on medications, doctor's visit for last times. Can I renew EAD beyond 1 year? I think these EADs are given on a 2-yearly basis, but I could be wrong. I don't remember the exact time frame, but yes, they are allowed on a recurring basis. What are the drawbacks of this EAD? Nothing really. I can't see anything really wrong with this EAD. It looks quite good to me. And I already covered the issue of taking unpaid leave. If you have a follow-up question on this, press *5. If you have a follow-up question, press *5. Okay. The next frequently asked question is converting, I should have said, from H-1B to H-4. There is a typo. I'll correct that later. Converting from H-1B to H-4 and back again, that is certainly possible. There is no problem with that. So the question that Meera has asked us is this. I'm on H-1B visa. I lost my job. I have I-140 approved, priority date of 2013. My 7+ years on current H-1B are over. I want to move on H-4 so I can stay in the USA. Oh, my wife have an H-1B, and so it's a gentleman, I guess. My wife has an H-1B visa with priority date 2016, etc. approved, I-140 approved. How many days can I stay in USA now as I lost my job on my H-1B visa? Well, the rule is you have 60 days to apply for another status following the loss of your job, as long as your I-94 is valid for those 60 days. So if the I-94 is valid only for 45 days, then you have a 45-day grace period. If it is only valid for 30 days, you have a 30-day grace period. So you're entitled to 60 days or duration of the I-94, whichever is shorter. If my wife filed the H-4 visa, then till application approved, rejected, can I stay in USA? Yes, you can. Can we file H-4 visa by ourselves? In other words, do I need a lawyer? Not really. It's a form I-539. I-539. I am not sure you need a lawyer for this. It's a simple, straightforward form, unless you have some extraordinary complication in your background. Yeah, just read the instructions on form I-539. 539, okay? I'm trying to find job. Once I find job, can I move back to your own H-1B from H-4? You can. The only problem is if the H-4 is not yet approved, it is still pending. There could be a little complication that might require you, in the worst case scenario, to go outside for visa stamping. But if the H-4 is already approved, you are fine. There is no issue then. I can't think of a better approach. H-4 is a good way to go. *5 if you have a follow-up question on this. *5. Okay. You can press *5 on your phone if you have a follow-up question. All right. So next frequently asked question is from V. Krishna. How long is an I-140 approval valid? Technically, an I-140 once approved is good forever. More recently, we have started seeing a pattern where if you have left the I-140 employer, government will try to go back and revoke your I-140 saying that the bona fide job is no longer available. I'm dealing with an issue like that right now, and the employer wants to keep the option open to hire the individual back. In those cases, I do not believe USCIS will be able to take away the I-140 because green card is for a job in the future, right? So therefore, to answer that question, technically an I-140 approval is valid forever. But the government is trying these days to revoke employment-based I-140s where you are tied to a particular employer. But if you have like an NIW, National Interest Waiver-based I-140 approval or EB-1A based, which are not tied to a particular employer, your I-140 is good forever. So you said that you are a self-petitioned case, so you could be either an EB-1A or an NIW. So technically, your green card is good forever as long as the activity because of which you processed your green card is still available when you come back. Okay? *5, if you have a follow-up question on this, press *5 on your phone. All right. Let's go on to see if there's any other frequently asked question. Okay, there isn't. Now there is one. There's a follow-up question. So let me go back to the last frequently asked question. Wow, what did I just do? Let's see. Give me a second. I'm trying to locate your, why is your name familiar? Okay, I'll just let you tell me what's going on. Go ahead, sir. You have a follow-up question?
Yes, sir. So, like I said, mine is an EB-1A, so self-petition, not tied to any employer. So what happens, my priority date is current. What happens if I apply for a green card right now and end up taking a job in December and leave US?
I think what you should do is, there are a couple of options you have. One option is, I think you should apply for your I-485, or you can make it even simpler. If you are sure you are leaving, just apply for an I-824 and convert your case to consular processing, which means in about 5-6 months, they'll start moving your file through the channels to consular processing in your home country. And you have a lot of flexibility in that movement. The way it works is, once I-824 is approved, which takes 4, 5, 6 months, your file will get sent to National Visa Center in New Hampshire, where you have 1 year to respond to their questionnaire, forms, etc. Once you respond to that, your file gets moved to the consulate. So this whole process can go on for a couple of years, and you can delay it without too much risk. Okay.
But if I don't get the job in December,
in that case, what you could do is, if you don't mind the extra expenditure, go ahead and apply for an I-485 now. And if you get a job, you can reconsider whether you want to even then just withdraw your 485 and convert your case to consular processing, or do you want to stay here till you get your advanced parole and then move? Because the advanced paroles are being given, which is permission to travel, they are being given for a validity of 2 years, I believe. So you should be okay to work outside USA until the expiration of the advanced parole is closed. Okay. So apply for 485 now, and you can always
withdraw it.
Change it. Yeah.
Okay. All right. Thank you. Appreciate it.
You're welcome. Good luck.
Thank you.
Okay. So let's go back to the beginning of our questions now, starting with all the questions that were not frequently asked questions. So mom and dad are here on green card. Brothers in India. they have been sponsored both by their parents as well as by you, Parul. I have a question regarding the new public charge rule, where the applicant is also required to show the income proof in addition to the affidavit of support. New public charge rule. Well, first of all, the public charge rules are under challenge in courts. There is, I think, 12 lawsuits pending. I'm not sure the public charge rule is ever going to get implemented, because on last Friday, the Form 944 was suspended because American Immigration Lawyers Association filed a lawsuit and obtained a temporary injunction. That was a form government was making us fill for all cases beginning October 15th. It was a horrible form. I think it was like 8 pages, where you had to submit things like your tax, your credit report, and things like that. And basically, the court said, no, you can't use this form. And at the same time, substantively, as the public charge regulations have been challenged, like I said, at least I think 12 times in different courts. And one of the grounds, which I think is pretty solid, that the Trump administration is trying to go beyond the statute. The statute itself does not permit the kind of nonsense this government has tried to put down on us. So I'm not even sure these regulations are going to be around for long. With that said, that's part of the reason I haven't been able to put too much time into it. Feel like it's a waste of time, hundreds of pages, which may or may not be applicable tomorrow. So your question is, can the parents take affordable care insurance premium credit? And my answer to you is, I do not know the future of these regulations. And also, the public charge area, the new regulations were only applicable to people who were applying for a green card after October, I think. Sorry. Those regulations were coming into effect. I don't remember the exact date. I think it was October 15th. So if you are not a new green card holder, they don't apply to you, as long as you're not violating the other conditions, which were the old conditions, such as long-term hospitalization, institutionalization, or cash supplementation. As I recall, taking any kind of insurance or public benefits should not be a problem. At least it's not an exclusion issue. Now, certain kind of public benefits, even though they don't violate your green card obligations, they can affect the person who has given an affidavit of support. So government can come after them for reimbursement. And it's a complicated area of the law, frankly. I haven't devoted too much time to it. I would suggest seek advice on it. We can look it up for you, but I certainly won't be able to do it immediately. And also, it may be better just to, you can also do it through a congressman's office. Contact your congressman's office and have them find the information for you. I don't think these rules apply, the new rules apply, but Trump administration has tried to tinker with the old rules by bringing in some new criteria, including an executive order that they just passed. And there's a question about that executive order today also. But even that executive order only applies to new green card cases, not to old ones. Okay. So I'm not even sure these new regulations are going to last. *5 if you have a follow-up question. *5. Press *5 on your phone. Okay. B. Patel says, my green card was filed under EB1C category. I-140 is approved. 485 is filed. I got married. She's on F1 status. I'm assuming she. Yeah, she. She abandoned her F1 status. I'm sorry, you can't raise your hand randomly, guys. I'm already in the next question, so just sit tight. Let me finish this one. I'll get to you. B. Patel, going back to her current status is pending H4. 485 is not yet filed because her dates are not current, okay? H1B extension has not yet been filed. Company attorney is not ready to file. They are asking me to change to L1A because they think H1 extension will impact my EB1C petition. I've already spent 3.5 years on H1B. No significant salary changes. I'm not sure. It's very difficult to give you an estimate of what is the better way to do this. I think you should get a second opinion. Somebody needs to take a look at your H1B. They need to take a look at your L1A, your EB1C, all three applications, and decide whether one will interfere with the other and whether H1B or L1A has a high chance of denial. You have to do that. I can't give you any meaningful advice without knowing all the details. So why don't you have your lawyers find somebody to get you, it looks like you have corporate lawyers, have them get you somebody to give you a second opinion. If my H1 or L1A gets denied, what are my choices? She can't be kept in status if the H1 L1 is denied. Obviously, she would have to step outside USA and come in with a new status once your visa is once your status is approved. So no, she won't have any way of staying in USA then. *5 if you have a follow-up question. Press *5 on your phone. Okay, somebody had their hand up. It's a toggle. Okay, so let's see, where is this from? This is from Virginia. Okay, let's unmute you. Yeah, Virginia, go ahead, please. What is your question?
Hi, sir. This is B. Patel. Thanks for your response. It was really helpful. Can you hear me?
I can, yes, perfectly.
Okay, all right. Thanks for your time. So yeah, that was a satisfactory answer. I just have a quick follow-up question. So if my company agrees to file H1 extension, and I have a question regarding 240 days rule. So if my H1 is pending until 240 days, since my 485 is already filed, so what will happen to me and my spouse if the petition is pending beyond 240 days? Can we stay in US legally?
Okay, well, there are a bunch of different rules here. Some are rules, some are policies. First of all, under USCIS policy, as long as your validly filed, timely filed case is pending, you and your spouse can both continue to stay, even if it takes 10 years. Okay? Clear? Second,
yes.
If you file a case as an extension without change, you have 240 days. But as I recall, if you file it as an amendment with some change, you have unlimited number of days to continue working. Okay?
So if it's a plain extension without any amendment, so just 240 days.
Then it's just you can work for 240 days and stay forever.
So same applies to my dependent as well.
She can't work, but she can stay as long as her case is pending with yours.
So, sir, if my company says you cannot work, but I have EAD, so if I give them the EAD and start working, so does it?
You can work on your EAD. So 240 days, you continue working based upon extension, and after that, you can switch to EAD. Only downside is to convert back to your status. Your spouse and you would have to step outside USA to get a visa stamping done if you start using your EAD.
Okay, got it. Thank you.
Okay, so that gets a little complicated. Make sure you talk to your lawyers about that. But I personally don't see why there is a conflict in an H1B or EB1C unless there is something in your particular facts that I don't know about. So that's why I want you to get a second opinion. Okay?
Sure. Thank you.
You're welcome. Good luck, sir. Okay. Let's see. B. Patel, we just finished this. So Sahara 24 says, I'm applying for citizenship through an attorney and also a renewal of a green card. Biometrics are done. I have a Class C misdemeanor criminal record which was expunged later. And we can't get all the particulars of it because it has been expunged. Is it okay to apply for citizenship along with just having applied for renewal of my green card? Yes, it is. What are my options to apply for citizenship through attorney? If the criminal case dismissal form has been lost, yeah, I think the only option you have is to get an affidavit that details your efforts to get the documentation, that details what sort of conviction it was, and to also argue to the government that Class C misdemeanor, I'm assuming sentence actually imposed was less than 6 months, if there was any. Therefore, you are qualifying under petty offense exception. So there's really nothing, even if you had that conviction fully documented, it would not have stopped your, well, actually, let me rephrase that. See, naturalization, they should look only at the last 5 years. They can, of course, go back further than that, but usually, statutorily, they are only looking at the last 5 years. So I think you're going to be okay on that ground. I was going to talk about petty offense exception, but that is applicable to green cards, not to naturalization. So I think the conviction is quite old. My guess is you're going to be fine. Now, I don't know the sticker, whether the sticker is enough to travel. I would have to look at what the Customs and Border Protection frequently asked questions say on this. But of course, getting an I-551 stamp in your passport is definitely as good as having a green card. Yeah, basically, you make an InfoPass appointment, take your copy of your green card and green card renewal application with you along with your passport. They should be able to stamp your passport. Now, you said you traveled to Canada, and of course, there's no record of that. That's okay. You should still mention it in your itinerary. Definitely. *5 if you have a follow-up question on this. Press *5 on your phone. Okay, we don't have a question, so let's go on to the next one. Sunny99 says, I'm working on an employer for the last 15 years, and I've got my green card. Now, 8 months later, I want to move. I don't think you have any problem. I don't think they're going to question that. I don't see any problem at all. So you said, it's been eight months since I got my green card. Can I change my job? Absolutely. I don't see any issue at all. Are printouts of articles about CEO change? You can keep them, but I don't think you need to justify your move after so many months. So you should be okay. Go ahead and change jobs. *5 if you have a question. *5. Okay. Let's go on to the next question. So you have a job as an adjunct faculty, non-tenure position. They don't do STEM extensions, but you have OPT coming. I'm planning to switch as my husband's dependent. His I-140 will be approved, then I'll apply for an H-4 EAD. Well, we don't really know what the future of H-4 EADs is. Government has said that they will probably move for H-4 EAD revocation in April, spring of next year. I don't think they can. I don't think they have enough of a ground. Otherwise, they would have done it already. But that's definitely a suspense point. If I were you, I would keep looking for a job. In April, I would apply for an H-1, whether it is through a quota or a non-quota employer. In the meantime, you can get your H-4 EAD done. *5 if you have a follow-up question. *5. Okay. All these questions we already dealt with. So Deepa has posted a question from Pawan Bairu. Is it allowed to travel out on EAD-AP while supplement J application is pending? Yes. I don't see why not. Can I travel out of states for 3 to 4 weeks? Yes, you can. If the EAD expires in the next 90 days, yes, you can. The one thing that remains unanswered is, what if your supplement J is denied when you're outside USA? Can you still use your advance parole to come back in? I think you can, especially if you still have a job offer from another employer in a same or similar position, because you can still file a supplement J. There's no limit to how many supplement Js you can file in case one of them is denied. Can I travel out of states while the EAD-AP extension is pending? EAD is no issue, but they had created some problems with advanced parole. If you go to the USCIS webpage on advanced parole, they have put down their policy now. As I recall, and I'm trying to reconstruct the rules because they have messed up this process so many times, sometimes it's difficult to remember what the rules anymore are. I think the rule is this. Let us say you have an existing advanced parole, and in the last 6 months of that, you applied for an extension. USCIS says you can travel and come back as long as you come back using the validity of the old advanced parole. So once again, 6 months remaining on your advanced parole, you have applied for an extension of advanced parole. USCIS, I think now they say you can travel and come back within those 6 months, and we will not consider the pending advanced parole application to be affected. If, on the other hand, you travel outside, you have a pending advanced parole, and your current advanced parole expires, not only can you not come back, the pending advanced parole is deemed to be abandoned as well. So that would be a problem. I hope that gives you your answer. Okay. *5, if you have a follow-up question on this, press *5. Yamini wanted to know if end client letter has a statement of work and a master services agreement, what does USCIS consider for approving H-1B validity period? SOW or MSA? Usually SOW. That's what they are trying to do these days. They will only approve it to the extent of the SOW. Press *5 on your phone if you have a follow-up question. Okay. Next question is from Fani. My wife moved to a different client location after amendment is filed with the same employer with the receipt notice. But now it is denied because of specialty occupation issue. She still has a valid H-1B until Feb of 2021 with the same employer. How many days does she have to file another amendment? Does she have to move to previous client location? I think that would be the smart thing to do. Move back to the previous client location and then file an amendment, or go on bench and file an amendment. Can she apply for another amendment with the same client for which her amendment is declined? Of course. As long as it's theoretically yes, but I don't know how strong the case is, whether there's a strong enough case. Is it better to apply for H-4? The problem is H-4 is taking so long to process. And during that time, if she gets another job, she would probably have to go outside USA for visa stamping. And it's a little difficult to answer all these questions because we are trying to project a lot into the future. But out of these, I think applying for an H-1B again is a good option. Okay. *5, if you have a follow-up question, *5. Okay. Let's go on to the next question. That's a frequently asked question. HPS says we have an approved I-140, but we are in India. If S-386 passes, are there any additional steps we have to do from India? I don't know. You can definitely not file a 485 from outside USA, but you can always convert to consular processing, and that's not difficult to do. So if I get a J1, can I file 485 under S386? Well, we don't know where this bill is going to go, if it's ever going to get passed, but the normal rule is if you have a home residency requirement, you cannot file an I-485. Now, the fourth question you have is kind of interesting, and I don't remember. I have to look up the regulations. The question is, when does the 2-year home residency requirement apply? When I get the visa stamping, J1 visa, or when I enter the USA? And I think the answer is when you enter the USA. If I recall, the regulations use the word something like admission. That means you actually enter the USA using J1, or change of status, which means you were already here and you converted to J1 status. That's my best guess. I don't remember off the top of my head what the regulation exactly says, but I think the home residency requirement only attaches when you actually use the J1 visa to enter USA. *5 if you have a follow-up question, *5. Okay. Oh yeah, here's a question from Texas. Texas, go ahead, please. Texas, go ahead.
Question. Yeah, can you hear me?
I can hear you, yes. Hello.
Now
I
have a US. So I have a US citizen child, and if I apply for a J1 waiver under exceptional hardship, how easy or difficult would it be between no objection and exceptional hardship?
Well, no objection is the easy one because it just takes a little time. But if you can get a no objection to return to India, getting a waiver is a lot easier as long as you have not taken U.S. government funding to any appreciable extent or Fulbright scholarship type of situation. So between the two, generally NORI is easier to go with, but if you have taken appreciable amount of USCIS, U.S. government funding, they may not, even though your government issues you a waiver, U.S. government may not be inclined to give you a recommendation for a waiver. In those cases, extreme and exceptional hardship is the better way to go. So general answer is it depends upon your situation.
Okay. And can I stay, does J1 allow you to stay in the country until a decision is made on the waiver?
No. Just having filed a waiver, as far as I remember, does not give you any special status. So just because you have a waiver going doesn't mean you have permission to stay in the USA.
Okay. And can the waiver be applied before traveling? Let's say, I have a 1 month before the J1 is approved, and before traveling, can I apply for a waiver?
Well, if
in the interest of time.
If you have enough time to on your J1 and J1 activity to get back into USA and resume the activity, I am not aware of any regulation that says you can't apply and then travel. But keep in mind, if your, for example, internship is over and you still have 30 days left, you can't really go out and come back during those 30 days if you don't have that internship any longer.
Right. So, is there time in terms of how much time does
you're gonna have to wrap it up. If you have one question, real quick question I can answer, I gotta go on.
So based on I have been on H1, do you think that I should take the risk of getting a J1 and getting into HRR, which has a 2 years
That's not a question. That's not a question I can answer, because it depends upon the program.
All right.
If you are taking any governmentally funded programs, U.S. governmentally funded programs, getting waivers is a lot harder. So I can't really answer that question. Okay?
All right. Okay. Yeah. Thanks.
Good luck.
Thanks. Appreciate your time.
You're welcome. Bye-bye. Okay. So Pash 1, 2, 3, 4. I've just got my guys. I think we're going to have. Let's see. We have. Oh no, I don't think we're going to have time for new questions because we have 4 or 5 questions still left. So this is from Pash 1, 2, 3, 4. Just got my I-140 approved through employer A. Want to switch jobs without waiting for 180 days because of a very good opportunity with employer B. Can the new employer file the H-1B transfer and extension together using my approved I-140? Yes, they can. They can. The only risk here is that government is trying to revoke already approved I-140s when an employee leaves. I discussed that at the beginning of the call. I think that's a very dubious approach. I don't think they can really do that. And I think somewhere along the line, somebody like you or me should come and file a lawsuit against them. But the only risk here is the law is once your I-140 is approved, you can use that to extend your H-1B through any employer. And once it's approved for 3 years, even if they revoke your I-140, which they cannot if the I-140 stays pending for 180 days. I-140 is approved and stays approved for 180 days. Even if they revoke, they can't take away your right to keep extending your H-1B. So simple answer is you can. Once the I-140 is approved, you can use it to extend your H-1B with any employer. Okay. Star 5 if you have a follow-up question. Star 5. Okay. Next question is from Aksal. We talked about public charge rule, and I was going to set up something. Yeah, but because of that, we knew there was a lawsuit being filed by American Immigration Lawyers Association. We didn't know what was going to happen. That lawsuit had been in preparation for a few weeks. So, and it actually did work out like that a court in Southern District of New York, a federal court, issued a nationwide injunction staying those regulations that they are trying to implement beginning October 15th. Now remember one thing, a temporary injunction, which we call a stay in one type of court language, it's actually technically a temporary injunction, is only issued where one of the things the court looks at is, do we have a chance of succeeding finally on the merits of the case? So I think government could end up getting the entire regulation scrapped. I'm not even sure these regulations are going to be around. So I'm not going to put any more time in these until we have a little bit of an idea where these regs are going. Okay. Star 5 if you have a follow-up question. So right now these regulations are suspended. They're not being implemented. Okay, next question is Rajesh 85. So the application for computer programmer was denied. You are now in India. Can I apply the software systems engineer? Of course you can. You see, I'll give you an example. Let's say I have a degree in computer science and I filed the job as a programmer or even as a QA analyst. Application gets denied. My new employer, number 1, wants to file as a database administrator. Employer number 2 wants to file as a network architect. Employer number 3 wants to file as a software developer. All 3 of them can file, even though a software engineer or software developer, a system administrator, database administrator, and a network architect are widely different positions, but I have a degree that qualifies me for all of them. So yes, absolutely. And you can go with premium, why not? Just because the previous application got denied doesn't mean anything. Star 5 if you have a follow-up question on this. Star 5. Okay. Krupa has a question. As per the latest President's proclamation, that's the executive order, all green card holders should have health insurance. That's not what the executive order says. It only talks about green card entrants after the issuance of the executive order. So it doesn't apply to old cases. Okay. So it does not apply to old cases. You don't have to worry about that. Just make sure you don't leave USA for more than 6 months, because then certain obligations, known and unknown, might be placed upon you. So if you leave USA before getting naturalization, just make sure you do it for less than 6 months at one time. Okay. *5 if you have a follow-up question on this. *5. Okay. Well, I still have 15 minutes left. I actually have a call scheduled. So let's say 12 minutes. Anybody has any question, press *5. Let me see how many I can get. Anyone has any question, press *5. So far, I have 2 hands raised. 3, 4. Okay. I'm going to try my level best to answer all 4. Guys, please try to keep your questions short. So I'm going to start first with California, who logged in first. California, ask your question, please.
Yeah, hi. I am a naturalized citizen, and I tried applying for green card for my parents. Because of a name missing issue on my birth certificate, they weren't able to establish the parental relationship, and they denied the I-130 even with the affidavits. They also have a visitor.
Give me one. Did you offer to do a genetic, what do they call it, a DNA test?
No.
Because you could have said, do my DNA test. They will do DNA test for your family, your parents in India, and DNA test for you here. Compare the results, and the parentage is established.
Okay. No, we didn't do that, but we missed the appeal window now.
You can refile the case.
Okay. Like, here is the thing. So they have a visitor visa valid till 2026. Can they now, like with the I-130 denied, can they now try to come as a visitor here and then apply through adjustment of status?
No, I have some frequently asked questions on this. Read through them. They cannot have a preconceived intention to get a green card. They should not enter using that. So just read through them, and understand that can get tricky, but you can always reapply for the green card. I don't see any problem with that. Okay.
Now, this is the last question. So does it mean consular processing is the only way possible to go forward?
No, I will not answer that question. That will take me at least 15 minutes. So you do have the option of doing many things, but read through the frequently asked questions. That's why we have them. I have discussed this issue at least 3 times in the last 3 months. Okay? I got to go on. You're welcome. Good luck, sir. Okay, this one is South Carolina. South Carolina, go ahead, please. South Carolina, go ahead.
Mr. Rajiv, this is Krishna again.
Yes, sir.
So I asked you about how long the I-140 is valid, the opportunity about going outside U.S.
Right.
So you suggested, yes. So you suggested it's possible that I can apply now. If I end up taking a job, I can withdraw it. So the question is, I have an interview scheduled for December. I'm going to the interview, and I have to go to India, get my H-1B stamped on my passport, and come back to U.S. So on the way, if I apply for I-485 now and go for the job interview in December, go to India, get my H-1B visa approved, coming back, is there anything that I should be concerned in terms of getting my...
This is not a 2-minute discussion, but let me tell you this in the time that we do have. It's a smart move to get an H-1B visa stamped first and then apply for 485. Get the visa stamped in Canada or Mexico. Okay?
Okay. All right. Thank you.
Good luck. You're welcome. Okay. Second last question that we will do is from Illinois. 1 second, Illinois. Yes, Illinois, go ahead, please. I can hear you. Illinois?
Hello, sir. Hello, Rajiv, sir. Yeah. Rajiv, sir, I consulted you and I filed my I-485 before my I-94 expire. And my question is, my EAD, family-based EAD on brother-sister category, it's more than 7 months. It's almost 8 months, but I am not receiving any update. So my question is, can I expedite it? Because when I called them, they said since your brother or sister is going to sponsor you. So my question is, based on medical reason, can I expedite or they will keep rejecting?
You can do 3 things. You can expedite based upon some personal reasons. You can contact the congressman's office to take their help in that. And third is to file a lawsuit. I have become more aggressive in my suggestions because it looks like government does move when lawsuits are filed. So that's something to consider. Okay? But first try. I would say approach your congressman, see if you can expedite through them. All right?
All right. Okay. All right. And can I ask another question, one more question?
If you make it really quick, I got about 10 seconds before I got to move on.
Okay. Yeah, sure. So my I-94 is expired and my H-1B got rejected. So can I file H-1B again based on I-485 pending receipt?
You can always apply for an H-1B and get it approved. To activate it, you will have to go outside for visa stamping, which is not the end of the world. Without getting into too many details, my advice would be go ahead, apply for the H-1B. That is the smart move. Okay?
Okay. Yeah, thank you, sir.
Good luck, sir. Okay, guys. I hate to be so rushy, but I have to move on. Last question is from New Jersey. So, New Jersey, go ahead, please.
Hello, sir. Thank you. Thank you for taking the time. The quick question that I have is, I have a serious heart issue, so that needs a surgery. So I know I'm eligible for EAD under compelling circumstances, but can I be once I get an EAD, can I be on a bench
yes.
on a bench
Absolutely.
on a bench during the EAD period? I have to be always on a payroll.
No.
Because post surgery, I might be out of work for at least 3 to 4 months because of my health issues.
Sir, I don't see any problem with that, because the whole point of a compelling circumstance EAD is that the availability for work could be uncertain. So I had a client who had a back surgery which caused him problems. Sometimes he could sit for 6 hours, no problem. Some days he could only sit for half an hour. Some days he couldn't go to work at all. So we got him an EAD, and the idea is because his availability was so uncertain, it doesn't work under H-1B, so getting him an EAD was a smart thing to do. So the answer is yes, you should be able to do that. Okay?
But what about the travel issues with this EAD? Can I travel back and forth within it?
Yeah, you can't travel. You can't travel, and I don't know what is the availability of advanced parole in those cases. I have to look into that. We've never done it. But an advanced parole might be the only option if you have an EAD. I have my notes on my blog. If you go to immigration.com and look at the top bar, it says Rajiv's blog. Click on that. I haven't written something for a while, I think almost 6-8 months, but I have written a very extensive explanation along with a short summary of compelling circumstances EAD. Take a look at that. That should help you.
Okay, sir. Yeah, that works.
Good luck.
Thank you, sir.
You're welcome. Guys, thank you everyone for being here, and I'll see you again in 2 weeks, next Thursday. Bye-bye.
every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.